And I'm really interested in this piece between the public law and private law piece because, like, I hear very clearly what you say around a public model that doesn't depend on maintenance being paid, and obviously we've discussed before the difficulty around enforcement, and clearly your baseline is you'd like this ideal scenario where money is transferred by whatever means, and I absolutely accept what you're saying about the philosophical piece, which I hadn't really thought about before until you'd phrased it in that way. And it's interesting because as we talk about child poverty, I think we fail sometimes to connect the language of failing to pay maintenance. Do you know what I mean? I think there's a broad. I think more people will connect with that language, more broadly situated. I'd love to know, perhaps Dr. Shannon and Louis and Ms. Bayliss, just how do we get to so how can we attach, say for example you want to pay maintenance as well and you reliably pay it and you're not, and I think that's not the baseline. You have a public model which is the baseline and maintenance can be paid on top of that. But our concern situation is where it's not paid, and how we can attach that. And I think what you said about the PPS number is really important. The extent to which maintenance can be conceived, because I still think it's important that the liable parent, as you were, that they do pay. Do you know what I mean? That it's not just the state. That this idea that it doesn't become an acceptable state idea that you can leave your child, or whatever scenario has happened before, but that you don't have any obligation financially to care for your child in some way. So I don't want to decouple it so much that maintenance ceases to be relevant to it. But whether that's paid from a court order that you simply bet that it's then paid to revenue, or it's attached to revenue, as you say, and it feeds into the Exchequer funding generally and goes to support a different model, or all of those different ways of considering that. And I was just interested, Dr. Shannon, in what you were saying about how far an agency can go, and I don't know if you elaborated on that following the Supreme Court, how far an agency can go beyond a court being involved, because the biggest difficulty seems to be with obviously access to court, with actual enforcement of the different models, and not just we've talked a lot here about maintenance, but enforcement of access, which I'm seeing again and again as an issue in different ways. And so I just don't, and again, you shouldn't, with an access issue, have to go back to court each time. It makes the issue much, much bigger than it needs to be when you're trying to have a harmonious life for a child. So I wonder if you can elaborate on some of those points, please. Oh, and then, sorry, I want to ask about Section 647. I'll do it in the second round, sorry.
It's a very important question, and it's a fundamental question, as I suppose my Director General has said, and I suppose I commented as a solicitor as well as as an academic. I sort of sail both worlds, yeah. So I think I have a practice perspective as well as an academic perspective on this. But as our Director General is saying, I think resources is a key issue. Because no matter what way we look at this, the system needs to be adequately resourced. I think there is a real challenge in not overstepping the parameters, and I think there's being ambitious on the one hand, and there's also being, making sure that we calibrate the balance in the correct manner. And how do we do this? Well, I think that we can be much more creative in the sanctions that we introduce for failure to pay maintenance. And I absolutely agree with all of the members of the panel that the failure to pay maintenance is a failure. It's really a red flag in terms of child protection, because of the fact that if you're not maintaining your child, it raises fundamental questions. And what I would suggest to the committee in addressing that problem is that we would look at broader sanctions which could be attached to a miscellaneous provisions bill, for example, at the end of any given year, such as garnishee orders, fines and imprisonment. And imprisonment isn't the right approach in respect of sanctions, and we've used that for access and we've used it traditionally for maintenance. But if in fact there was a power to pursue somebody who's failed to pay maintenance retrospectively, that's curtailed at the moment to a very short number of months. If we removed that, and if you could target the defaulting parent's assets, so look at it not in terms of as a criminal sanction, but also in addition to that, what I would suggest is you could have a fund. You could create a fund. So how do you bridge that gap between the public and the private system? Is to create a state fund,
like an MIBI for maintenance.
Yeah, for maintenance.
And there's something there, but the difficulty, of course, in creating more and more sanctions, that is, it's more and more court. Whereas if you can remedy at the outset, so let's say a court makes an order that you're going to pay €200 a week for the next 10 years or whatever it happens to be, or until I say differently.
Yeah.
And revenue, revenue are notified, and it's just managed in that way so that we don't have to go back and back and back to judges all the time. And then if you can create, is there a way of creating a power in statute for somebody in that agency to be the enforcer of that, or to be that coordinator with revenue?
And that's what I was suggesting earlier. I was suggesting
Yeah.
earlier is that you invest as much power as you can in the child maintenance agency. And you really extend that to its limits, because that's the real potential.
Where's the limit of that, do you think?
The limit of that would be, obviously, it's a sanction that would involve depriving somebody of their liberty, would be. But I think that if we look at what happened, and I think I can assist the committee by saying, is to look what happened when the Child Maintenance Agency was established in the United Kingdom in 2012. They ran into huge problems with enforcement. And the best way to deal with this is a alternative dispute resolution. So what you try and do is you have an elaborate system for engaging with parents at an early stage, and that you create that in a more sophisticated manner than currently exists. And I think there's huge potential in that, because if we look at some of the other international models where that has occurred, it has occurred with a degree of success. And I think that that's the real potential. But let's not pretend that there's a magic bullet. There's no magic bullet here. But what you need to do is look at the powers you could grant to the agency and support the agency in terms of resources, but also in terms of alternative dispute resolution. Try and get as much agreement as you possibly can. And I think that can be achieved. And if we look at the scheme, the Family Court Bill envisages this as being the new order. Why not have that reflected in a maintenance context? And that's what I would commend to the committee.
Can I go to the second round?
Yeah. You can come in again, if you like. Yeah, that's, yeah. Well, I'll tell you what, we'll take a few more responses now, because there's while people have their hands up, yeah?
I was just going to add another point, and at risk it's slightly outside the formality of the court, as you were saying, is that, over the years, I can think of several scenarios where we've had some success with, and forgive me if I say fathers, we've had some success with fathers when we've framed things in a different way, separating and unhooking it from the other partner. And what I mean by that is that when you say non-payment of maintenance or other issues, certainly framing them as financial abuse, but also framing them as a parenting choice and facilitating them in a process of seeing their actions in the context of their father-child relationship, their parent-child relationship. And while obviously it's not a magic bullet, as Jeffrey is saying, but sometimes for that reflection and having services that actually focus on that kind of therapeutic end to say, this is the impact on your child. Let's focus back on your child. Let's not focus on your ex-partner. Let's not focus on what she did or didn't do. Let's focus on your current choices and your current actions and frame them as a parenting choice. We have seen some movement. And sometimes then, children tell us, and it is in the children's best interest to have a meaningful relationship with both parents most of the time. That is the scenario. So the goal to get that is that for that relationship to be meaningful is for parents to see their actions as parenting choices. So I think that's what can we do now. We can invest more in services that do that kind of work, that create opportunities for those kind of discussions to happen, so to exhaust the opportunities for therapeutic improvement in how people understand their actions. And then if that doesn't work, then obviously more stringent recourse, as Jeffrey was saying there.
Sorry, I know the point you've made there about linking maintenance with seeing, I think that's so important and insightful and helpful. Thank you very much. And actually, I can't believe it's 10 years since the children's referendum. I had forgotten, and so much of that was attempted to give effect through the Children and Family Relationships Act in 2015. But it's so but what I'm hearing from constituents, and I think the first thing I said in the Dáil was about Section 47 assessments, and about how they can be used and abused, how the calibre of them, that people conducting assessments had to have been trained in coercive control, I think was the point I'd made in 2020, that wasn't necessarily apparent, that children were participating in them, giving a clear view, and then a report was coming out that said something very different. So I don't know if that situation has improved over time in relation to Section 47. It has not, is the indication. Okay, it hasn't. That's a universal no. Okay, I'll hand that over to you, Ms. Kiernan, please. Yeah.
Thank you, Deputy.
Okay.
The issue of assessments to court is key. And currently we have Voice of the Child reports, which are done by child abuse experts, which there is a level of regulation and cost control on. And there are difficulties with that. The Section 47, which are the child welfare reports, there's no regulation whatsoever. There is nowhere for parents to go. We have had parents report to us very serious concerns about their assessors, and there's nothing they can do. There is no professional body they can go to. And there's an interesting case in the UK at the moment, actually, over this and the qualifications of someone doing these reports. So there is a huge requirement on the state to regulate at a minimum people who can do them. But ultimately what we need, as was picking up on what we've said and what Steph and Bernardus is saying, is there's a lot that can be done for much lower cost outside of court. That's what we do day in, day out in one family. You can have people come to realisations, to agreements, and you don't have to go down the court route or they get ratified in court. We're doing research at the moment, Trinity and UCC are doing research for us on access for infants in separated families. And they are saying their voices need to be heard. Now, we're not hearing the voice of children who are much older than that. There is no system. If you can't afford to pay, it's not happening. So we are not vindicating children's rights in the Constitution at the moment, and that's really problematic. And ultimately where this goes is that each family is different, each child is different, and you need somebody skilled who's able to look at that situation, listen to everybody, because children cannot hold the responsibility of picking whether they get to see a parent or not. They can be consulted, but they cannot make that decision unless they're much older. So people, there has to be a system around to do that. We have proposed a model in our submission to the Family Justice Oversight Committee around a family law services model, which would complement what's going to be done in the courts, because it will not be as successful as it should be unless these things are done. But assessments and the quality and timeliness of information that goes into court is key. And, I definitely sense a reluctance on behalf of the state to regulate or fund or support any kind of reporting on families. And yet that is what ultimately is needed for the success and closure of cases, which means a happier family and less trauma, because our systems are causing adverse childhood experiences. The separation may not be, but the trauma and the process that families have to go through are actually causing adverse childhood experiences, which people like us and Thusla are then need to look at and count to see how traumatised a child is. Well, the state is complicit in creating these, unfortunately. There's so much that can be done, and if child maintenance could be removed from the family law arena, there would be more resources to be able to do that bit of it properly, and that only that what has to go to court should go, and 80-90% of this should be done outside of court, and that's across all family law issues, not just maintenance, but also access, custody, guardianship, all of those things.
Thank you.
Thank you.
Dr. Shannon is.
Do you want to come back in, Mr.?
Yeah, I think you raised a really important point, because if we look at the system at the moment, your Section 47 report refers to Section 47 of the Family Law Act of 1995. So we have a system in private family law cases which is unregulated. And those are cases which are divorce, judicial separation, really high stakes cases where in fact you're reordering an entire marriage. You're reordering the assets of the marriage. So what we have in standalone applications, which are governed by Section 32 of the Children and Family Relationships Act of 2015, we have a regulated system. We have the child view expert. So what we have failed to do, and we've heard Ms. Kiernan outline the consequences of that, we've failed to regulate the procurement of these reports in private family law cases. So there's a failure to, in my opinion, to provide sufficient regulations. And certainly the Law Society's Family Law Committee have been calling for some time for robust regulation, because the reports that are provided to the Circuit Family Court are reports that ultimately will decide who is granted custody or access. So this is an issue, in my opinion, that needs to be dealt with as a matter of priority, is that while we have regulation for discrete custody and access applications, we don't have it where it's dealt with as part of a private family law matter. So I think the time now is to ensure that those regulations are introduced and that citizens are protected. And that absence of regulation, I think, ultimately could have very devastating consequences unless we move immediately to fill that lacuna.
May I just clarify, did Ms. Kiernan say earlier the triangle of, was it childcare, criminal and family law, the information sharing? Thank you.